Okay, folks. Well, this will be an interesting or different type of lecture than you're used to because instead of standing in front of you personally, I am here digitally. But that doesn't mean that we can't cover a lot of good material today. I hate to waste a class period. I hate for you not to get your money's worth out of a class that you're obviously paying for. And so wanted to make sure that we preserve this Thursday for your elucidation. The roll sheet will be going around. I don't know exactly when it will be passed around, but it will be going around. Make sure that you get your initials on it. Obviously, I can't take questions during this class period, so this class period might be a little bit shorter than the hour and 15 minutes. Probably will last somewhere between 50 and 60 minutes regardless. This is the policing class. This is lecture number 5 for this course. And this lecture is over the rights of the accused. Why would we talk about the rights of the accused in a policing class? Well, the answer should be obvious. If you're going into law enforcement or you're working with law enforcement in any other capacity within the criminal justice system, you will end up working with people who have been accused of crimes, sometimes people who have been convicted of crimes, which we're also talking about those rights in this lecture as well. A couple things to keep in mind about this lecture. We have constitutional rights and we have political rights. The distinction between the two include that constitutional rights obviously come straight from the founding documents of our democratic system. The Constitution was written in 1787, went into effect in 1790, and by 1792 or 93, we have the first 10 amendments to the United States Constitution, which form what we know colloquially as the Bill of Rights. It turns out that lots of the provisions of the Bill of Rights are also protections for people who have been accused of crimes by the government, okay? Why would we build protections for people who have been accused of crimes by the government within our constitutional democratic system? Well, part of it was a direct reaction to abuses of power prior to then. So prior to the 1790s, individuals living in the original 13 colonies of the United States may have been subject to abuses of power by the government under which they lived, particularly King George III, Great Britain, imposing their power in a way that many colonists believed infringed upon what should be protected liberties. So we're going to actually take a look at how we've reacted to that over time, how we've built in provisions that protect citizens from their own government in order to ensure fairness in the criminal judicial process, even after they have been convicted of crimes in some cases. Okay, so this is your lecture on the rights of the accused. I'm going to hide over here in the corner. You'll still be able to see my ugly face. That's okay. I'm going to make my face smaller, be more tolerant to you. And we'll go ahead and get started, okay? So this is the 6th Amendment to the United States Constitution. We'll talk about the 5th and the 8th as well. What I've tried to do here is highlight where we have different protections within the same amendment. So I'm not trying to be confusing with the highlighting. I'm just trying to show that the 6th Amendment covers a lot of territory, and so does the 5th. And even though it's extremely short, so does the 8th. And these are the primary sources that we have of our protections as subjects of a democratic government in a constitutional system. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. So we have basically 3 things right there in that one incomplete portion of a sentence. The right to a trial is the obvious part in yellow. The right for that trial to be public, okay? And then also the right for that trial to be speedy. We're going to talk in this lecture about what all of that means, maybe without talking about the right to a trial. That's probably a given, but it certainly falls under the expectations of due process, or the process that is due, that a citizen should expect under a fair judicial system that gives them the right to respond to allegations against them. That's essentially what a trial is. So that charges are brought against you, and you get to respond to the charges brought against you. And then, at least in theory, you have a neutral or impartial decision maker, such as a judge or jury. And we have extra protections when it comes to that. But what does speedy and public mean? Well, those might be a little more relaxed than we want them to be. And that's going to be sort of another theme in this lecture. You'll see the theme from prior lectures coming forward, where we've seen the historic expansion of the Terry Stop Doctrine, the historic expansion of under what circumstances can you conduct a stop and frisk, under what circumstances can you arrest without a warrant. How broad is the definition of probable cause? It seems to be expanding and expanding and expanding in each subsequent Supreme Court opinion, which ultimately means an expansion of state power over the citizen as opposed to citizens' individual liberties. Same thing here with all of these protections of the accused. They are often very narrowly interpreted, where the judicial branch of government pretty much keeps their hands off as much as they can, interpreting these provisions as narrowly as they can to keep, to basically preserve government power, okay, to preserve authority over individual liberty. So what's the next part here? By an impartial jury of the state and district wherein the crime shall have been committed. So this is your right to a jury in criminal prosecutions. Then in pink, to be informed of the nature and cause of the accusation. So you have a right as a criminal defendant, someone who has been accused of a crime by the government, to be informed of the nature and cause of the accusation. So what is the difference between nature and cause? Ultimately, what this means is we believe that you violated X law, and then maybe cite what law you have arrested the person under or you're accusing them under, and then what their conduct was that violated that law. If you are a person who has been arrested, or you're a person who has had their rights abridged in any type of punitive way by the government, you would want to contact a lawyer and have them file what's known as a habeas corpus petition. Well, what is habeas corpus? Habeas corpus is a Latin phrase that most directly interprets into English as show the body. In this particular case, we're not talking about like a murder victim. We're talking about the body of law under which you have been accused. So when your attorney files a habeas corpus petition with the government, they're saying, hey, judicial branch, force the executive branch to tell me why I have been arrested. Make them prove that my arrest has cause. Okay, usually that happens, like, for example, if you've been arrested but no trials have taken place, no hearings have taken place, maybe there hasn't even been any type of adjudication at all, no arraignment, no initial hearing. Well, if you've been in jail for that long, you have a right to know why. And the habeas corpus petition is the proper method to find out why. And if the government cannot show why you cannot show their cause for why you are imprisoned, then a judge is judicially authorized to require your release. In blue, you have the right to be confronted with the witnesses against you. Great. So that means that even the person who's accusing you of a crime, maybe even the crime victim themselves or witnesses to it, have to be available to you or your counsel for cross-examination at trial. They don't get to just give their information to the government and then walk away. If you have follow-up questions you want to ask them, if you want to grill them on the stand at trial to defend yourself, then you have the right to do so. And then it says to have a compulsory process for obtaining those witnesses. Well, what is the compulsory process that we have in the American political system for the obtaining of witnesses? We call this the mandatory subpoena power. So when you have been indicted for a crime by the government, you also have the ability to force people to be present at the trial, even if they don't want to be, in order to answer questions about information that they have. And they would be sworn in with an oath requiring them to be honest. And they would have to share their information even if it was exculpatory, which is to say something that favors the defendant as opposed to the prosecution. And then their failure to be honest can result in charges for falsifying information before a court, also known as perjury. lying on the stand. Okay, and then in red, assistance of counsel. So we'll talk about the Supreme Court opinion that determined how broad the guarantee of the assistance of counsel or the providing of counsel for indigent defendants, people who can't afford an attorney. We'll talk about how broad or narrow that might be. Then we have the Fifth Amendment, another laundry list of protections for criminal defendants. Except maybe for the first part, there's a little limitation here. So what is everything before the second comma? No person shall be held to answer for a capital or otherwise infamous crime, aka a felony, unless on a presentment or indictment of a grand jury. So we have this word grand modifying jury, implying that it's a different kind of jury than your normal kind of jury. We're not just talking about 12 people in a jury box watching a trial and then making fact-based decisions on, whether or not a witness was trustworthy or whether or not a certain gun was the murder weapon. No, instead we're talking about a grand jury. On the federal level, you can only indict a person, which is the word we use to mean bring charges against a person in federal criminal court. You can only indict a person if the grand jury, a room of your peers, a room of random citizens plucked from society and kind of forced into service for this role, agrees that charges should be brought. Okay, so there's some protection against the government just willy-nilly bringing charges against you because some U.S. attorney thinks it's appropriate by themselves in their own head and in their own analysis. The only way charges can be brought against you on the federal level is when this grand jury, this room of your peers, which might not even be accessible to you, you might not even have a right to see them, but they have to agree that it is appropriate for those charges to be brought, that there is some evidence that makes sense to bring this thing to a prosecution, okay? Now, let's be honest. The threshold for an indictment before a grand jury is very low. They don't need proof beyond a reasonable doubt. That's what a trial is for. So in terms of convincing a room of your peers if it's appropriate to bring charges, not the most difficult thing in the world to do, especially when you take this into consideration. It might only be the prosecutor who ever sees them and ever gets to talk to them. And they can spend a lot of time with them. And they can show them all kinds of evidence. And there's no rebuttal from your side because you don't necessarily have a right to go into that room and see them. So as far as rights go, this is a very weak protection for criminal defendants. Nonetheless, it's still a protection. Okay. Why do I keep saying on the federal level? Well, this has not been one of the rights in the Bill of Rights that's been incorporated to the states. So when you think of things in the Bill of Rights, the first thing that should come to mind is something like free speech or right to bear arms, freedom of religion. Those are all rights in the Bill of Rights, originally only interpreted to limit federal government actions. But over time, the courts have said that a lot of those provisions within the Bill of Rights are also restrictions on state governments, not with the indictment before a grand jury. That is one of the few areas of the Bill of Rights that remains only a restriction on the federal government. So the state, in state court, there is no grand jury, and there is essentially full prosecutorial discretion on whether to bring charges against you. Why is this important? Well, for one, it means that protection doesn't exist. But for another thing, we have to keep in mind most prosecutions, most criminal prosecutions in the United States, in fact, well more than 90% of criminal prosecutions in the United States are state-level prosecutions, not federal indictments. So not only is the grand jury protection minimal even in the federal system, it's only in the federal system, okay? So we can move on from that. We're not going to dwell on that too much because it's clearly not something that even the government cares that much about, even the Constitution cares that much about. Then it says in green, you cannot be subject for the same offense, be put twice in jeopardy of life or limb. So this is your classic phrasing for the no double jeopardy requirement at law. You cannot be put in double jeopardy, twice put in jeopardy for the same crime. We'll go into detail on that. We're just looking at the amendment language right now. Nor shall you be compelled in a criminal case to be a witness against yourself. Okay. So, I mean, when you saw the phrase Fifth Amendment come up, you should have immediately thought, oh, that means the no self-incrimination rule, right? Notice how much is also in the Fifth Amendment that we gloss over. But yes, this is the amendment that says that you cannot be a witness against yourself. The government cannot force you to answer questions that would be incriminating. You cannot be forced to confess. That's a protection that you have. Okay. You cannot be forced to produce evidence against yourself. Not just be a witness against yourself. You cannot be forced to produce evidence against yourself. You cannot be deprived of life, liberty, or property without due process of law. Now, one thing to keep in mind, especially those of you that might be interested in law school later, do not get Fifth Amendment protections for due process confused with 14th Amendment protections for due process. Those are two separate amendments. They both have their own due process clause. They both look similar, but they both mean slightly different things. As far as the Fifth Amendment is concerned, we're talking about legal or procedural due process as opposed to substantive due process. I'm not going to get into substantive right now, but what you need to know as far as due process under the Fifth Amendment is we're talking about the process that is due to you in terms of procedural capacities of government, such as you get to know the charges brought against you, such as you get to have a trial, you get to have hearings, you get to argue your case. That's what due process ultimately is. Now, there's other elements that we'll talk about here in a moment, but we're not talking about other particular civil rights concerns. Nor shall private property be taken for public use, this is in red, without just compensation. So the government cannot take your private property and then use it for public use, comma, except with just compensation. So ultimately, what is this saying? The government can take your stuff, even if it's private property, and use it for public use, so long as there is fair compensation for the taking. There is a legal phrase for this in the modern world, and we call it eminent domain. Eminent domain, by itself, you wouldn't know what the phrase means, but now you do. Eminent domain means the government taking your property and giving you the fair value of it. Not what you consider to be the value. In other words, if the property is like, ran in your family for centuries and has something more than its monetary value, like a sentimental value to you, that's not what the Fifth Amendment says. It just says just compensation. So the appraised value, what it would go for in the marketplace, that would be the value that you get. So, I hope none of you have a highway built through your property anytime soon, but if you do, and you go find a lawyer and say, they can't just take my house and take my farm and take my trees, they can. They're just going to give you whatever your home is appraised for. Eighth Amendment protections. Excessive bail shall not be required. So that's a vague word, excessive. What's excessive in terms of bail? Good question. Nor shall excessive fines be imposed. Okay, bail's different than fines. Let's characterize that right now because I'll forget to later. Bail serves one purpose in our system and only one purpose in our system. Bail is the insurance that you will show up for your court date or some type of trial date in the future. In other words, it's basically an exchange with the judge for the security of his peace of mind that you won't just skip out of state, out of country, and try to avoid the charges. Well, what kind of motivation can you give a criminal defendant to actually make their trial date and not skip out? Well, you put money on the line, right? You say, okay, you're going to give me $100,000 or the collateral thereof, and you're going to get it back, but only if you show up for your court date. Well, you get it back, great. And all you have to do is the good citizen thing, which is show up for the meeting you said you'd show up for. So that generally seems fair to most people. Where we get into a problem is what's considered excessive bail, where bail is so high that the citizen who has, now been put in the situation of needing to meet that bail requirement actually doesn't have the wealth to even meet it, which means, okay, well, you're just going to cook in jail for a while until your trial happens. There's a lot of objections within the criminal justice system and within criminal justice reform advocacy about reducing or eliminating bail by itself as a system, and instead just replacing it with determinations of whether you should be released or whether you shouldn't be released. And those determinations are generally made on not whether you'll show up for your trial date, but whether you're a danger to the community. We hold you in jail if you were a mass shooter, because it doesn't make any sense to let you out even if you could afford $1 million bail. And we let you out if you've been accused of drug possession, because you're not necessarily a danger to the community, right? You're not out there harming people, at least in an active way. Okay. And then fines, of course. Fines are just punishments in lieu of imprisonment. You can get a fine for littering, okay? It's supposed to act as a disincentive to criminal conduct. But at what point would the fine be considered excessive? And then finally, no cruel and unusual punishments. That's actually far more descriptive than whatever the meaning of excessive means. No cruel or unusual punishments. I think most people can read that sentence and come to some pretty reasonable conclusions about what would be cruel and what would be unusual. So let's start from the beginning and just start going through these laundry lists point by point. In general, criminal prosecutions should go to trial on the federal level within 75 days. We have some prior case law, and like I said, I don't need you to know case names. I don't always share them with you, but we do have some really good prior case law that says on the federal level, you should expect your trial within 75 days, barring any type of reasonable reason for the delay. Well, here's the thing about this rule. There's lots of reasonable reasons for delay. There might be difficulties in gathering evidence. There might be reasonable extensions for depositions, or what's called the discovery phase of trial, which is way before you're ever putting together arguments before a court. You're just collecting information. You're interviewing people who were witnesses in the form of a deposition or having them fill out an affidavit. You're looking through crime scene photographs. You're even conducting some more investigation about the facts of the case. If there's any number of reasons that attorneys on both sides might want more time than 75 days to prepare a case for trial. And so for that reason, what ends up happening, even on the federal level, is you get trials that are not speedy. And then it's still considered to fit within the framework for a speedy trial. Outside of the federal level, there's even more leeway, because there's practically an admission in the judicial system that states are slower than the federal government and that they might take even more time. There are many counties in Oklahoma that only have 2 trial dockets per year, which means every 6 months. We consider that speedy, apparently, because it's still considered to be constitutionally valid to wait that long. And then we have this presumption of openness to the public. Presumption of openness to the public. This has been seen by many criminal defendants as somehow punitive to them, but I'm here to tell you it was originally designed as a protection for the criminal defendant. The person who has been accused by the government at least 200 years ago would most likely see the openness of their trial as a good thing as opposed to some act of public humiliation. Why would that be? Well, because at least after the American Revolution, there was a lot of suspicion of government overreach. And in particular, suspicion about government making decisions, especially about somebody's, life and limbs, and doing that behind closed doors with no scrutiny, no media, no witnesses to that trial. Maybe the trial was completely unfair. Maybe they allowed in evidence that they shouldn't have. Maybe they were incredibly biased. Maybe the judge was biased. How would anybody know if it was all behind closed doors? The defendant could come out and say, well, that was the most unfair trial ever. Nobody would be able to corroborate it because nobody was able to watch the trial. So there is a presumption of openness to criminal trials. In other words, the public gets to go watch the trial, the media gets to go watch the trial. This isn't to be confused with things like cameras in courtrooms. In fact, the longstanding judicial practice on this has been to prohibit cameras, which is why we get things like, courtroom sketch artists, and we've all seen those types of things. But it is becoming more common for courtrooms to even allow cameras in, okay? But cameras or no, there's always been a presumption of openness for the entirety of our constitutional system, that if you, just as Joe Citizen, want to go down to the courthouse and watch a trial, you can walk in, sit down, and watch a trial. Okay, it's a really great help to people who want to go to law school, get an idea if everything that's happening in front of the bar, that's where we get the phrase, the Bar Association. Everybody who gets to walk in front of the bar, attorneys, if you ever want to do the stuff that's in front of the bar, maybe go watch a trial and see if you're interested in doing that kind of thing for a profession. Okay. Look, my video is in the way of words here. There we are. Cruel and unusual punishment, etc. So this is Eighth Amendment analysis. Cruel and unusual punishments. Okay, well, we all saw the Eighth Amendment just moments ago. We know that cruelty is a pretty good synonym for torture. So the most obvious rule of the Eighth Amendment is you can never be sentenced to torture. We don't do drawing and quartering in the United States. We don't do intentional infliction of pain in the United States, not as one of our methods of execution, although compared to most of our peer countries, whatever richest countries in the world, developed nations, we actually are sort of unusual in the fact that we do still retain the death penalty. That does make us, compared to other developed nations, pretty weird. I'm not here to express an opinion on that, but it's true. We are kind of weird that we still have capital punishment. Weird in the sense that we're an outlier, not weird in I'm judging it or anything like that. So we don't have torture, but we do have death. No fines that are grossly excessive and amount to deprivation of property without due process. So this is part of the no excessive fines portion of the Eighth Amendment. Once again, the definition is just as vague as the original wording. What this ultimately means is that the judicial branch is very skeptical about saying that any fine is excessive. Now, I think we can all agree that like $1 million fine for throwing your Starbucks cup into a ditch is going to be considered grossly excessive. It's just that we don't actually know with any level of precision what the dividing line is. Would $1,000 be excessive? Apparently not, because there are plenty of states where that's considered to be appropriate, even for something as simple as throwing your Starbucks cup into a ditch. So that's the sort of the open question. Can it be $50,000? We don't really know the answer to that question, okay? And then deprivation of property without due process. Well, then what about deprivation of property with due process? If you go through, all these hearings, well, I didn't throw my Starbucks cup in the ditch, and then, the government still thinks you did after they gave you due process, then can they assess a fine of $50,000 for that one act? We still don't know the answer to that. Your big takeaway here is no strong limits on the excessiveness of fines, even though that is the wording of the Eighth Amendment. There still does not seem to be any strong prohibition on it. The courts say that bail must be reasonably calculated to secure presence at trial. Well, that makes sense because that's the whole point of bail. It's an insurance policy to make sure that your butt's in a seat when your trial comes around on the docket. Okay, so, maybe for a low-level crime, like a simple assault or a DUI, I don't mean to diminish the nature of those crimes, but, we're not talking about a homicide here. Maybe the bail would be lower than something than first-degree murder. That makes sense because you're less likely to show up to your murder trial because you've got a lot more to lose. You have a far greater incentive to leave the state. You have a far greater incentive to leave the country or go into hiding, okay, than you do for the other punishments. So there's a sliding scale when it comes to bail. It must be reasonably calculated to secure your presence at trial. And The inverse of that would be the prohibition. If it's not reasonably calculated to secure your presence at trial, but instead it's really just punitive so that you wouldn't be able to pay it anyway, and you're just going to have to, rot in jail until your trial, that might be something that's found unconstitutionally violating the Eighth Amendment. The Furman v. Georgia case is a 1970s case that says punishment cannot be arbitrary, cannot be one that is rejected by society. Hello, unusual, right? The exact word in the Eighth Amendment is unusual, which really means uncommon or rejected by society, okay? And then cannot be patently unnecessary. The punishment cannot be patently unnecessary. We do get into some conversations within the criminal justice system about when judges come up with unusual or creative punishments. We are very used to a term of years in prison. That's a very routine punishment. We are very used to being sentenced to something like community service or to probation, or fiddling around with when you're eligible for parole after your term of years. That's what we're used to. And judges default to those things all the time because they're very normal, and we've got structures built around those to enforce them. We've got probation and parole officers, we've got corrections officers, we've got a structure around that. But judges can still get creative. There's no prohibition on other or creative sentences for many crimes. Now, for some, there are prescriptive crimes. We call those mandatory minimum sentences or sentencing guidelines that states pass. But for a vast majority of misdemeanors, judges in most states get to wing it. And that's a lot of discretion. So you every once in a while come across a case, just as an example, where a judge says to a misdemeanor defendant, sometimes even a low-level felony defendant, well, you're going to have to, as part of your sentence, you're going to have to apologize to the victims. Okay, well, that's getting a little creative, but it's not wild or crazy. It might make some sense. But then you also get cases that say, what you're going to do for your DUI is you're going to go outside onto the public sidewalk and you're going to wear a sandwich board. And on both sides of that sandwich board, like you're marketing something, okay, it's over your shoulders and it's this placard for advertising. And it's going to say, I'm a drunk driver and I'm not going to do it anymore, or something like that. Okay, well, that's public humiliation. But it's not explicitly prohibited by the Eighth Amendment. In other words, it's one of those things that some judges do sometimes, and it's allowed. And so we could probably have a decently healthy conversation in this class, at least when I come back on Tuesday, about, is public humiliation a reasonable sentence for a misdemeanor crime? And if so, what kind of limits on that public humiliation should there be? Are we one of the countries that could go back to putting people in stocks in a public square? Would that violate the Eighth Amendment? Probably would. But where's that dividing line between wearing the sandwich board and being placed in the stocks? Could we come up with a definition? Could we come up with some sentences that actually describe the difference between the two and hope that judges understand what that is? I think it's a decent little debate. No death penalty for minors. No death penalty for the mentally handicapped. And please don't be offended by the phrasing there. I know it says mentally handicapped. That's probably not the most politic way of phrasing it, but it is the way the Supreme Court phrased it in one of its holdings. So I'm just trying to, kowtow to their language there. No death penalty for minors. When I went to law school at the University of Oklahoma, one of the professors up there was Rick Tepker. He's taught there, I think, since the late 70s, at least since the early 80s. And his claim to fame was the only Supreme Court case that he ever argued. He was actually appointed by the Supreme Court to represent an indigent minor who was accused of murder, found guilty of murder, sentenced to death for murder, even though he committed the crime when he was under the age of 18. And so he won his only Supreme Court case. And he won it on constitutional grounds under an Eighth Amendment analysis, saying it is considered cruel and unusual to execute a minor, even if they killed a person and have been found guilty for it, convicted, because they committed the crimes as a minor, and it just seems disproportional to us. It seems cruel. Okay? So, interesting holding there. A little bit more on the Eighth Amendment. A lot to cover here. Trump v. Dulles case, 1958, says that you cannot revoke the citizenship of a natural-born citizen as a criminal punishment. You cannot revoke the citizenship of a natural-born citizen. Interesting modifier. What if they're not a natural-born citizen, but they're a citizen? So a naturalized citizen, someone who wasn't a citizen became a citizen. Does this, by implication, mean that their citizenship could be revoked as a criminal penalty? We don't actually know the answer to that, because after 1958, on the federal level, they just got rid of any revocation of citizenship as a form of penalty. But if they ever brought it back, we'd probably almost immediately get a really interesting Supreme Court case about, well, how broad is this prohibition really? Does it only apply to natural-born citizens, or does it apply to naturalized citizens? Another interesting thing about the Dulles case, in the dicta of the opinion, we know that the judges and justices on the Supreme Court write out their opinion so that we can read it and we can understand their analysis as lawyers if we're, trying to advise clients on future conduct. Okay, in their dicta, they said that they considered the revocation of citizenship to be worse even than torture, because even a tortured person would then be able to claim rights under some government somewhere, whereas the revocation of citizenship essentially makes a person completely stateless. You can't get a passport. You're not protected by any laws. And so that was their analysis. It may have been a slight exaggeration, but that's how serious they took this violation of the Eighth Amendment. They said, man, this is worse even than torture. Coker v. Georgia, 1977. The death penalty is considered to be excessive for rape and, by implication, all non-death crimes, minus maybe treason. So overall, what we get from this 1977 case is, if we're going to execute a person as a criminal punishment, as the sentence they get for their crime, then they better be being executed for something that is extremely bad, in fact, so bad that it caused a person's death or amounted to aiding the enemy in wartime. Literally aiding the enemy in a declared war. Anything short of that, then death as a punishment might not be considered proportional, at least insofar as an Eighth Amendment analysis under cruel and unusual and what the meaning of those words mean would allow. Graham v. Florida. This is a recent case, only 9 years ago. No life sentence. The government cannot give a life sentence without parole for a crime other than murder to a minor. Now remember what we said in the previous slide here. The Thompson v. Oklahoma case, that last bullet point down there, down at the bottom, no death penalty for minors, okay? No death penalty for minors. But here, in the Graham v. Florida case, we're going further. No life sentence without parole for a crime other than murder for a minor. So, no death penalty for minors and no life sentence without parole. By the way, Miller v. Alabama expanded this even further and said even if they do commit a murder, you still can't give them life without parole if they committed the crime as a minor. If they were under 18, not the time of trial, but at the time the crime was committed, they were under 18, you cannot execute them for the murder, and you cannot give them life without parole, even for murder. So, open question here, and there's probably an obvious answer. Can you give them life with parole? Basically everything but. Most likely the answer is yes. We don't have these are recent cases. We're figuring things out for the first time, apparently. Wilkerson v. Utah, really old case, 1878, during Reconstruction, you know, after the Civil War even, but it has not been overturned. Okay, we're going to go through a short little string here of cases that still have valid law because they've never been overturned by the Supreme Court. And this is the case that says, well, we don't consider a firing squad as an execution method to be cruel and unusual. So basically it's allowed. We are a country that, you know, if you kill someone or commit treason, we'll kill you back. That's, you know, in some ways part of the American tradition. But we do have restrictions on how you may conduct the execution, because once again, we don't allow torture. We don't allow the intentional infliction of pain in the method of the execution. The incidental infliction of pain, fine, but not the intentional infliction of pain. Well, it turns out, and I sort of, the rationale here makes sense. Many people, when they choose to in their own life, will use a gun to do it, right? So, allows the using of a firing squad as an execution method. It's relatively quick. I don't know if you could accurately describe it as painless. I don't know how we would ever know. It's not like we can interview anybody, but a rational mind can reach the conclusion that it's not the intentional infliction of pain, therefore it's allowed. Kremlin v. Michigan, 1991, not been overturned, but raises a interesting little nuance. It allows the life sentence without parole for the possession of 1.5 pounds of cocaine. So this is not like the world's worst crime. This is possession of a lot of cocaine. But we're not even talking about like a whole pickup truck bed. We're talking about 1.5 pounds. So, I mean, yeah, it's not like personal use amounts unless somebody's stocking up for the future. But this shocks the conscience of a lot of people who might think, oh, that seems pretty cruel and unusual. To give a person life without parole, you are gonna die in prison for the possession of 1.5 pounds of a substance that can be created from things in nature. By the way, on the federal level, marijuana is still a Schedule I controlled substance on the same level as cocaine, which means the possession of 1.5 pounds of marijuana would fall under this exact same analysis. So does that raise your eyebrows at all? Is it something that we might want to talk about on Tuesday when I come back to class? Maybe. Rommel v. Estelle, 1980, allowed the life sentence implemented by a state's 3 strikes law, even though the total amount of damage from those thefts, they were probably robberies or burglaries because they were felonies, total amount stolen, $230 in all 3 combined. Dude stole $230. But it turns out that he did this in a state with a 3 strikes law. 3 felonies and you're out. 3 strikes laws are controversial because they usually don't take into account how bad the felonies were, just whether they were felonies at all. And so if you do 3 relatively, you know, the types of felonies that we don't consider particularly egregious, even if they're felonies, like this guy, he wound up serving a life sentence for committing 3 crimes, none of which were murder, none of which even directly harmed other people. May have put them in fear. If it's a burglary or robbery, certainly, you know, it's the kind of thing where you're pointing a gun at a person. It's bad behavior. No, not saying it's not. But this is another case that shocks the conscience of a lot of people where they say, if it weren't for the 3 strikes law, you would have just received the penalty appropriate for each individual felony, you know, 2 or 3 years for each of them. You'd be out, you know, in what society might consider a fair punishment. To the people who say that they're shocked by this case, they say nobody in their right mind, no reasonable person would say that this is an appropriate penalty for this behavior. Well, I mean, on a logical level, they're probably wrong, at least insofar as that's considered, because otherwise, why would these states, which ostensibly are democracies, have passed the 3 strikes law in the first place, knowing that this might be a consequence? It's a healthy debate to have. Once again, we don't dwell on the controversial in this class, but we don't ignore it either. So what about the right to assistance of counsel? Gideon v. Wainwright, 1963 case. Now we know from the Constitution itself, we know from the Bill of Rights, that you get, if you cannot afford an attorney, you get the assistance of counsel. It's one of the things you get as an American citizen. If you can't afford one, one will be provided for you. Just 3 years later, we got the Miranda v. Arizona decision, okay, that where we actually tell people in so many words, you get an attorney. So what is the Gideon case? Clarence Earl Gideon was charged in Florida State Court with a felony. The felony was breaking and entering. He didn't kill anybody. This wasn't the worst of crimes. It was breaking and entering. He appears in court without a lawyer, says he can't afford one. He requests that the court appoint one for him. He's read his Constitution. He's read his 6th, 7th, and 8th Amendments. And he says, you're supposed to give me an attorney. Well, according to Florida state law at the time, an attorney was only appointed for an indigent defendant. Indigent just means poor, basically, in capital cases. Capital cases are cases where death could be a punishment, which we just learned can only be if you killed a person or committed treason. So the trial court did not appoint him an attorney, even though he could not afford one. So he proceeds sans attorney, without one, okay? Turns out he was able to appeal this decision, and he won before the United States Supreme Court, which said the 6th Amendment guarantees a right to counsel in criminal cases for felony defendants, as well as any defendants who risk imprisonment. So misdemeanor, felony, doesn't matter. If prison's on the line, you get an attorney, even if you can't afford one. There's no excuses that a state can come up with and says, well, we give them attorneys if it's a homicide case. You don't get to draw those distinctions. The only distinction that matters is prison on the line? If so, they get an attorney. Now, just to delve in this slightly deeper real quick, I hope we've talked a little bit in this class about how controversial it is, where most states, in fact, a bare majority, about 28 states out of the 50, they make the determination of whether or not you get an attorney paid for by the government. They make that determination on the basis of whether you fall within federal poverty guidelines. Okay. Well, the federal poverty guidelines go down to pretty low incomes. There are a lot of people who make very little money who aren't technically, under those guidelines, impoverished. Okay. So you're a single person, but you make $23,000 a year. That's not a lot of money. It's not. No judgment. But you're also probably not, under the federal poverty guidelines, considered to be in poverty. But is that level of income going to be sufficient for you to pay an attorney, even a not very high-priced attorney? Typically not. So you have plenty of people who are not indigent in a technical sense, yet still cannot afford to pay their counsel. And they are stuck in limbo land. Gideon v. Wainwright does not help them. Their employer does not help them, might not even give them the days off that they need to go to a trial. So they might lose their income and become indigent, and then all of a sudden Gideon's triggered. Happens more often than you might think. Any number of times people get arrested and can't afford bail, they lose their jobs. It puts people in a really tough spot. It's a question that has not been resolved by the criminal justice system, okay? We know the exclusionary rule in this class, right? Evidence found in violation of the Fourth Amendment or other restrictions on government authority beyond the Fourth Amendment, say, for example, Miranda warnings. Any evidence found in violation of these protections must be excluded from the trial for the purpose of showing guilt. There are some exceptions to this. In other words, evidence might still be allowed in trial, even if it was improperly acquired by the government, for reasons other than showing guilt. So what's an example of this so that we understand? Well, okay, let's say that I found drug paraphernalia, but I did an improper, unconstitutional search. I did not have probable cause for the search as the police officer, but I went into somebody's pockets, or I went into somebody's car, or I went into somebody's home, and I got the stuff anyway. Well, okay, exclusionary rule applies. I collected the information in a way that I, as the government, was not allowed to do. So I can't enter it in evidence to prove guilt. But let's say that the accused defendant is up there, takes the stand, let's say, and is just lying his tail off and says, I never owned this, I never had that, I was never in possession of this. You are allowed at trial to show that evidence for the limited purpose of impeaching them as a liar, to show that they are dishonest. The evidence is allowed in for that purpose. It's just not allowed in as evidence of guilt of a crime. I know that's a technical distinction, and I know you're thinking, well, if the jury sees it, then they see it. Game over, right? Well, that's one of the complicated things about the way we do criminal trials. Miranda v. Arizona, one of the most misunderstood cases that protect criminal defendants in the history of American jurisprudence. 1966 case. Another one of those things that sort of raises my eyebrow, where we go, you know, ever since 1790 with the Constitution, and all of a sudden in 1966 we decided, oh yeah, we should start telling people before we interrogate them that they have rights. Wow, we only learned that in the 60s? So what are the facts? On March 13th, 1963, Ernesto Miranda is arrested in his house, brought to a police station where he's questioned for hours about a potential kidnapping and rape in which he is the suspect. After interrogation, police obtain a written confession from Miranda, but Miranda later says that he was pressured into confessing, that it wasn't a genuine confession, it just was the only way to leave the room. It was the only way to stop the badgering, and therefore he confessed. Okay. The written confession is admitted into evidence at trial as proof of guilt. Makes sense, right? The police have received a confession. Of course I'm going to enter it in evidence as trial as proof of guilt. The police officers admitted that they had never Mirandized Ernesto Miranda. Why? Because we didn't have a Miranda rule. This is the case that creates it, right? This man becomes famous. Okay, so they had not read him his rights prior to interrogation, his Sixth Amendment rights and his Fifth Amendment rights. They had not read those to him. They interrogate him. As a result of the interrogation, they get a confession. And so the question is very simple. Do the police have an obligation to read a person certain rights that they have prior to interrogation when the person being interrogated is in custody, is not free to leave, and is surrounded by essentially the police superstructure? Guns, badges, police cars, flashing lights, holding cells, and the like. Things that might be intimidating to a person or make them want to feel intimidated. The jury found Miranda guilty in his trial. He says, well, you never should have allowed that evidence. I want it overturned so that you can take my confession, rule it inadmissible, and give me a retrial. We get this holding from the United States Supreme Court. Law enforcement must inform a suspect who is in custody, in other words, not free to leave, of their right not to incriminate themselves and certain other rights. We all know what the Miranda warnings are. You have a right to an attorney. If you cannot afford one, one will be appointed for you, free of charge. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You don't have to read this immediately to a person who's just being detained in a Terry stop, okay? You have to read this to a person who is essentially, for all essential purposes, never going to be free to leave, at least for the purposes of a full interrogation. The important part is the interrogation. You are going to be asking them questions in which the accused person, the suspect, would be incriminating themselves if they answered those questions. That's why this protection attaches, that people should know that they actually are not required by law to answer the police questions, or at the very least, that they can have the assistance of counsel during any such interview. So after these warnings are given, then it is fine for a criminal defendant to just knowingly and intelligently know that they know their rights, waive those rights, and go ahead and answer questions. And for many criminal people who are accused of crimes or people who are in any type of custodial interrogation, they, especially if they feel like they have nothing to lose and they've done nothing wrong, they might go ahead and answer those questions. I would never advise it, even if you have not done anything wrong. Always get a lawyer if you're in a custodial interrogation. If you're ever read Miranda warnings, please exercise the rights that are read to you. Should be common sense advice, but most people go ahead and waive their rights, and then they get into, you know, a little bit of scrutiny, even if they hadn't done anything wrong. So what is a custodial interrogation? It means you're not free to leave. Interrogation means questioning, specifically questions that go to guilt or non-guilt. So we're not just talking about a police officer engaging you in conversation during a routine traffic stop. Interrogation can also mean indirect comments the police knew would elicit a reaction on these matters, guilt or non-guilt. What do I mean by that? So it's not a direct question. It's not, you know, why'd you kill that guy? Okay, that's an interrogation. No, this isn't a direct question. This actually comes from a specific case where a guy is picked up by the police and he's with his attorney initially, like literally when the police are there, the guy's with his attorney. He's being accused of major crimes. And so his attorney talks to the cops and they got to transport him from one location to another. In fact, it's totally this guy's intention to later confess to the crimes. He just wants to do it in the right setting and with his lawyer present and do it in all the ways that protect him in the most appropriate ways. And so the lawyer secures a promise from the police that they won't interrogate him while he's in the back seat of the squad car being transported in some distance. And the police say, oh, no, we won't ask any questions. Well, they sort of keep that promise. They don't ask any direct questions. But what one of the officers does while the suspect is in the backseat of the squad car, he does this monologue that is intentionally designed, very obviously intentionally designed to elicit a confession out of the person in the back seat, even though it's not a direct question. And the form of this monologue, it's called the proper Christian burial speech. If you Google that phrase, if you're interested in learning more about criminal justice tonight, which I know you always are, just impatient to come back to this class, want to Google things. Google the Christian burial speech. And what it is this police officer in the front of the car says, gosh, the family of this missing girl, and it turns out that she was killed. The family of this missing girl, they just want to do what's right with their faith. They want to give her a proper Christian burial. They deserve to know where her body's at so that they can do what's right with God. Notice there's no question there. Not in the traditional sense what we would consider an interrogation. But what happens? Yeah, the guy in the back seat develops a conscience and says exactly where the evidence is. So what does the Supreme Court say? Well, the Supreme Court says you don't get to do any proper Christian burial speech because that is an indirect comment that the police know would elicit a reaction on these matters. You can do it if you Mirandize them first, but sans Miranda, no indirect comments that the police know would elicit that reaction. Okay. Television has made us think that you must be Mirandized immediately upon arrest in all arrests. That's false. Do not believe television. This was a tactic used, especially in the early 80s. Remember, crime was increasing really bad in the 80s, and it peaked in the early 90s. Crime was at its worst in American history during 1990, 1991, and 1992. Okay? So a lot of the movies that came out around that time sort of celebrated police a lot because, in the mind of the public, well, the police are exactly what's going to save us from this massive crime wave. And so the climactic moment of any number of, sort of criminal procedural movies was when they're slapping on the cuffs and the police officer says in a gruff voice what the Miranda warning is, you have a right to remain silent. And it was, it might have given a thrill to the audience or the viewer, but it was not an accurate representation of police work. Go ask anybody who works as a police officer, they've already been taught at the academy and they already know you don't have to Mirandize a person just because you're arresting them. If they're in custody and you're performing an interrogation, sure. If you intend to ask them even 1 or 2 questions that go straight to whether they are guilty or non-guilty and this person is not free to leave, then yeah, they're going to pull out their little card. They're going to make sure they read the Miranda warning word for word just so that there's no legal question about whether they read it correctly. And that's when it's going to attach, not when they're slapping the cuffs on. In 90% of arrests, you just need to get the person to jail. You're not investigating anything anymore. You get all kinds of criminal defendants go to jail, and the first thing that they tell the booking agent at the jail when they're given their name and maybe their, the things that are in their pockets, they say, well, I know I'm going to get off on this. You know why? You know why? And so the booking agent will roll their eyes because they've heard it 1,000 times, and they'll say, why? And the criminal defendant that's being booked into the jail is going to say, he didn't read me my Miranda rights. They're wrong. He didn't have to read you your Miranda rights. If the custodial interrogee requests an attorney, the interrogation must stop immediately. Okay, cool. Not that complicated of a rule. If the person requests an attorney and they don't currently have one, the interrogation must stop immediately. The reason it has to is because if you were to ask another question, it can be considered badgering. And if they do answer a question, it's not going to be admissible in court. Silence by itself, and this is important. If the person who you are interrogating actually just instantaneously exercises their right to silence, and they just sit there quietly while you're asking them question 1, question 2, question 3, and their lips aren't moving, they're just, then you're allowed to keep asking questions. Maybe you'll get lucky, and once you get to question 7, they decide, oh my God, I'm going to answer that one. Okay, sometimes that happens, fair enough. However, if your criminal defendant actually says in so many words any version of the phrase, I wish to remain silent, I will exercise my right to remain silent, I choose not to answer questions today, sir, then you can't keep asking questions. Why? Because then, even if they do develop the epiphany that they do want to answer, it's not going to be admissible in court. Okay, so silence alone, yeah, you can keep asking questions. Maybe you'll get lucky, they answer one, it's still admissible. But if they actually say that they're going to exercise their right to silence, that's when you need to shut up. And then the question of breaking custody. You can imagine that any number of cases have come up where a person's Mirandized, then they take a break from questioning, they sit back down again. Do they have to be re-Mirandized before the interrogation resumes? Well, this is one of those totality of the circumstances things. It depends an awful lot on how long the gap was, whether it was obvious and clear at the conclusion of the first session that there was going to be a second session and when it would be. Usually if it's overnight, no, you got to re-Mirandize them. But if we're just talking like a quick lunch break, usually not. There are some exceptions to Miranda where it would ordinarily apply, but legally we choose that it shall not apply. This includes during routine booking, where you're giving the booking agent your name and the things in your pockets, and whatever search incident to arrest takes place, you got to, that might be evidence used against you, but they can't let you, go into the jail cell with a knife in your pocket. So all that kind of stuff in routine booking, things that you're required to answer during routine booking is an exception. You don't have to be Mirandized. Also jailhouse informants. So remember, part of the rationale for Miranda is that we don't want people to be intimidated into giving false confessions. We don't want people to be intentionally intimidated by the police at all. And, it creates problems within the judicial system when such intimidation does take place. But when we're talking about a situation where you have a discrete jailhouse informant, like, for example, the police have been relying on a particular person within the jail to supply them information about what other inmates are saying, maybe as a trade for they'll get out earlier, or they'll have somebody write a good little essay for them for their parole hearing. Great. You're allowed to be a jailhouse informant without Mirandizing the person that you might be getting confessions from. So if the person you share a jail cell with leans over and says, what you in for? And you say, well, I'm accused of homicide. And they say, so did you do it? And you say, yeah, I did it. They don't know that, though. They get to take what you just told them and go tell the authorities and then testify to it in court. And there was no requirement that you should have been Mirandized first. Why? Because this isn't a case of intimidation. It's a case of trickery, but it's not a case of intimidation. And that's what we're concerned about. That's what the Miranda warning is intended to protect. These long, grueling, badgering interrogations that tend to produce faulty confessions or otherwise harass the criminal defendant. And then there's the public safety exception. There was a case where a guy was getting arrested for a gun crime, and the gun could not be found, but the crime took place very close to a schoolyard. And so the police, even though it was sort of like a custodial interrogation, they did not Mirandize him for fear that that would mean he wouldn't answer any questions. And they asked him one question. Hey, buddy, where's the gun? Because what's going to happen is the school's going to come out to recess and somebody's going to find it, and then somebody's going to get hurt. So can you tell us where the gun is? And he does. He says where the gun is. And then later the gun was used as evidence against him in a court of law. So he says, you should have Mirandized me first. Turns out this falls within the public safety exception to Miranda, asking the accused criminal defendant, even when they're in custody, even when it's essentially a custodial interrogation, even without giving them Miranda rights, you're allowed to ask things like, where's the gun? So long as if it were found, somebody'd be in danger. Where's the bomb? Or whatever the case may be. Okay. Fifth Amendment due process. Fifth Amendment due process. Not to be confused with 14th Amendment due process, which we don't cover in this class. What does it require? It means that the criminally accused defendant has to get a fair procedure. They have to go before a completely impartial judge or jury. They have to have the chance to examine the evidence that will be presented against them at trial, and to have sufficient time to examine that evidence and see if they can poke any holes in it and explain why that evidence might be faulty, or why it shouldn't be believed, or why it might have been fabricated, or why it might have some reason to be untrustworthy, okay? The ability to cross-examine witnesses. Always think of witnesses as a form of evidence. So you get access to that too. You can poke holes in their stories. You can impeach their recollection. You can impeach their honesty. You can try and show the court why they shouldn't be believable, or why they might have ill motive, like they have an axe to grind against you, and that's the reason that they're coming up with this testimony that's detrimental to you. That's all part of the Fifth Amendment. The keeping of a tribunal record. Ultimately, this means that there has to be a record of hearings in the trial. So this is why in the court system you have these professional transcriptionists that are writing down every word. That's part of your Fifth Amendment right. So you can always go back and say, I didn't say that. Look at the transcript. Look at the transcript. I didn't confess to that. There's proof. There's evidence about whether you said something or whether you didn't, or whether the state said something or whether they didn't. And then, of course, last but not least, the right to produce evidence of your own, the right to show the court evidence of an alibi. Like, I've got this witness that says I was with him at the time of the bank robbery, therefore I couldn't have done the bank robbery. So you definitely have the ability to produce your own witnesses, your own physical evidence, your own expert witnesses to describe any physical evidence or other information in order to defend yourself against the government accusation. Double jeopardy. If you've ever seen the movie Double Jeopardy from the 90s, first, don't, because it's a bad movie. Second, don't take it as a police procedural or a lesson in constitutional law, because it gets it all wrong. In the movie Double Jeopardy, a person thinks, and the movie apparently thinks, that after being acquitted for a homicide, that since there's a rule against double jeopardy, that now, if that person's actually still alive that they thought I killed, I can go kill them because I can't be put at risk of life or limb twice for the same crime. And I've already been acquitted for killing this person. It turns out they're still alive, so I get to go kill them. That is not how this works, okay? How does it work? Well, the Fifth Amendment says no person shall be subject for the same offense to being put twice in jeopardy of life or limb. So basically what this means is no two trials for the same crime. The government only gets one crack at you, and if you're acquitted in the first trial, they don't get to be like, okay, well, they're just going to keep filing charges over and over and over again until we get a conviction. Double, triple, quadruple jeopardy is not fair. It is not fair to criminal defendants. The government gets one crack at you with some wiggly exceptions. So if a defendant's acquitted, the government does not get to appeal the acquittal. If the defendant is convicted and the conviction is upheld on appeal, he may not thereafter be re-prosecuted for the same crime. Maybe the government wants to get a stiffer penalty, or they want to charge them with something that's bigger than the lesser included offense. No, you only get one crack at them. If a defendant is not convicted, in other words, he's acquitted, he may not thereafter be re-prosecuted for the same crime. The exception here is what we call dual sovereignty. The federal government has sovereignty, and the state government has sovereignty. They may very well have overlapping laws that make the same conduct criminal conduct. Okay, it might not even be the exact same type of law, but as long as both governments, separate governments, have this separate rule against whatever conduct it was that you did, then both sovereigns maybe do get a crack at you, but they each only get one. So under the dual sovereignty doctrine, multiple sovereigns can indict a defendant for the same crime that covers the same circumstances and same events on the same days at the same time. They can both file indictments against you because they have overlapping criminal laws, but they each only get one crack at you. If the state government fails to convict, but the federal government actually secures a conviction, too bad for you. You're not protected by double jeopardy in that circumstance. Okay, so that concludes our lecture on the rights of the accused. If you have not signed the roll sheet, please make sure you do so. If you have taken notes of questions you want to ask after this lecture, bring them with you to class on Tuesday. Sayonara.